Good morning, everybody. I hope everyone can hear me. Sorry, good afternoon. Thank you all for attending today. My name is Hank de Jong, and I'm a senior partner of the firm Jonge Read. Over the next 40 minutes, my business partner Ben Heaney and myself will be presenting to you all some further information in relation to the pre-insolvency space and our firm Jonge Read. The agenda for the day will cover the insolvency industry in the current landscape, Phoenix activity and corporate restructures, personal insolvency, and to tie all this together, we'll finally look at some case studies in which you can see the true value of pre-insolvency in practice. We've just run the introduction video, and I think some people may have had some issues in hearing that, and for that I apologise. We did test it beforehand. Anyway, to get things started, we start off with the insolvency framework in Australia is ultimately designed to assist individuals, corporate entities, unsecured and secured creditors to bring finality to insurmountable debt positions. It's by no means a perfect system and should be carefully navigated. A clear example of this is the receivership process in the small to medium-sized business sector. Clients that are genuine about working with the bank will definitely achieve a better outcome for all parties through an informal process. Unfortunately, standard bank practice is to engage insolvency practitioners to investigate and prepare recommendations in relation to defaulting clients. This often results in the recommendation of the appointment of a receiver. We see countless examples where this process has clearly not been in the best interest of the creditor or the client. Getting the right advice is really the key to anyone experiencing any insolvency situation. We say there on the screen, would you self-represent or even worse, obtain advice from your ex's lawyer? But surprisingly, that's what a lot of people do when facing insolvency. An insolvency practitioner has an obligation to represent creditors, not the director or the individual. This prevents them from providing strategic advice to the company director. With this in mind, who should the company director rely on to navigate the insolvency framework and to evaluate alternatives? This is where the true value of good pre-insolvency advice becomes clear to many directors. Our industry is fairly well regulated, and we've got two regulating bodies, being AFSA and ASIC. ASIC regulates corporate insolvency, and AFSA regulates personal insolvency. It's very important that anyone going through an insolvency event understand their obligations and the process. Naturally, most business owners are not familiar with the formal insolvency process, and really nor should they be. There are many things that can be done to improve the outcomes for directors and individuals. However, it is imperative any strategy is correctly implemented within the law. Otherwise, the outcomes could simply be overturned. The current landscape is ever-changing, and I guess what we've got here on the screen at the moment are five of the main issues that we've seen major changes in of recent. The first one is the PPSA. The PPSA opened the field further for insolvency practitioners to claim assets that were previously quarantined. Asset management departments of banks are being more receptive to sensible informal workout proposals. Currently, we're finding the NAB to be the most commercial and BOQ to be the toughest. We've also seen an increase in the ATO collections team pursuing matter through to formal insolvency without giving any consideration to commerciality. We also have seen related party asset sales prior to liquidation receiving further investigation from ASIC, especially under the new Phoenix laws and so on, which we'll go into a little bit later on. In addition to ASIC, the ATO is now also investigating possible illegal Phoenix transactions. And finally, we see wider industry acceptance of the pre-pack restructure process being evident. The current landscape clearly indicates that company directors do need to be properly advised. With this in mind, a carefully planned and executed pre-insolvency strategy can save business owners thousands and kickstart their future. Business Quite often we see businesses who have experienced an event that has dramatically affected their turnover or profitability. This could simply be employee embezzlement or a significant change in the industry. In these cases, the business often has a solid core and the director has significant expertise and passion for the industry. These situations lend themselves well to a pre-pack corporate restructure. Phoenix activity. Phoenix activity, without a doubt, is a buzzword in the industry and has been for a while. But it's important to understand what Phoenix activity really is. Phoenix activity involves winding up of a company and continuation of business activity. Phoenix activity, or a pre-pack, on its own should not be confused with the issue of illegal or fraudulent Phoenix activity. There is still no statutory definition of illegal Phoenix activity. The major differentiating factor between a Phoenix or pre-pack and an illegal Phoenix transaction is where commercial consideration has not been paid by the customer, by the purchaser. The Jonge Read process ensures supporting valuations, documentation, and payment also form part of the corporate restructure process. Pre-packs, I guess a big part of the Jonge Read process is how we put all this together, and what we've got listed here on the screen is all the different steps that form part of a business restructure. So to walk through this, the definition of a pre-pack is the sale of business and or assets of an insolvent company, which is agreed prior to the appointment of an insolvency practitioner. Typically, the assets or business are sold for market value to a related company who re-employs the existing staff and produces the same goods and services from the same premises. The business and assets need to be valued by a reputable valuer. The sale needs to be correctly documented. Commercial consideration needs to be paid. The business continues to be operated by the new company with no interruption to customers and stakeholders. The insolvent company then appoints a liquidator who will then investigate the sale and report to creditors. If the process is done correctly and commercially, the expectation of management will be that the liquidator ratifies the sale. An important element of this process is that the liquidator should not advise on the process. Unfortunately, as part of corporate insolvency, bankruptcy quite often is a lead-on effect for a director. So leading on to this, directors often face personal insolvency issues due to personal guarantees and DPN action from the ATO. This can often be deemed as a catastrophic outcome. However, this is not necessarily the case. If correctly managed, some comforting points are: they won't necessarily lose the family home. The family business, if correctly structured, will be quarantined. They won't necessarily lose the car. It's not advertised, so their next door neighbour won't know. And finally, they can travel and work overseas if necessary. Furthermore, when we explain how bankruptcy can be correctly managed, along with the fact that this action can bring finality to all personal debts, personal guarantees, and all claims, often a huge weight is lifted from our clients' shoulders. A part of the bankruptcy process often involves the family home, and one of the things that our firm specialises in is looking at exoneration claims for people facing bankruptcy. One of the most interesting points is correctly managing the exoneration of the family home. On the slide, we look at the exoneration to a jointly owned property by husband and wife. In this example, the husband has been forced to enter bankruptcy. Previously, the husband had utilised some of the equity in the home to fund an overdraft for his business. Calculation 1 shows how a trustee in bankruptcy would normally view the equity position in the home. Calculation 2 shows how Jonge Read would present to an insolvency practitioner using the doctrine of exoneration. The final result of Calculation 2 has all the equity vesting with the wife, as the overdraft is subtracted from the husband's share of the equity. This example shows that the trustee in bankruptcy has no claim against the equity in the property. For every bankruptcy managed by Jonge Read, approximately 50% of our clients go through a Section 73 process, on which we obtain an average of around an 80% success rate. A Section 73 annulment of bankruptcy is quite a popular course of action for clients who wish to borrow funds at competitive rates in the future. A Section 73 annulment allows for a settlement offer to be made to creditors during the bankruptcy, which, if accepted by creditors, will cause the bankruptcy to be annulled. 10 to 20 cents in the dollar seems to be an acceptable offer. Any signs of the bankruptcy is removed from the client's CRA or Vita report, however remains on the NPII and the Dun & Bradstreet index marked as annulled. To be successful in obtaining a Section 73 annulment, the creditors vote on the proposal for which we require 75% in dollar and 50% in number of the creditors in attendance at the meeting. The key difference is that the Section 73 is a full and final settlement. It's annulled, null and void, and never existed. I'm now going to hand over to my business partner Ben Heaney to talk a little bit further and specifically look at some case studies where these strategies that we've looked at today come into action.
Good afternoon, everybody. My name's Ben Heaney, and thanks for attending. Hank's run through a lot of the technical elements and a lot of information in a short space of time. What I'll do is run through 4 case studies which will hopefully pull together these different areas that we've discussed and show you how they can be put together to get a client in a difficult situation a pretty good outcome. When I run through these case studies, I think that there are some common elements between all people that are in difficult situations, and this is firstly that they do need advice. Secondly, their outcomes can always be improved. It's never too late, no matter what stage of the process they're at. And also it's a very stressful and emotional time. So people in these situations do need quite intensive guidance and hand-holding and comfort and understanding of the process along the way, and that's most certainly what our service is all about. So moving on to the first case study, this case study that I'll run through is quite a vanilla or simple case study, but the results that we were able to get were exceptional for the client. Now, the background of it was that it was a busy gymnasium and it was located in regional Queensland. It had an above-market property lease arrangement in place that was falling behind, and it also had very excessive borrowings on plant and equipment that was put into place in the past when they purchased the business. The business was actually part of a franchise arrangement. The situation was that the fixed cost base meant the business was running at a loss. There's nothing that the directors could do to change this, of course. It did have very good membership bases. It did operate within industry standards. So on that side of it, the directors had done everything that they could. But the bottom line was the business was running at a loss due to the fixed costs, and over time both significant statutory debts as well as trade creditors did accrue. One of the directors got a second job, and with that second job they were pumping money back into the business, but still that was not enough. We met with the director to talk about options. The director was passionate about the business and did want to continue trading if there was an option, and so we recommended to go through the pre-pack corporate restructure process that Hank had on one of the earlier slides that he ran through. So the strategy was to sell the business to a new entity, in this case without plant and equipment, and the director of the new entity in this case was the son. This gymnasium was a family business and the son was very involved in the business inception. Now the fair market value of the business was supported by a business valuation. The next part was that we entered into an agreement between the vendor and the purchaser whereby the plant and equipment was rented in the short term. Now the reason for this was that there was significant amounts owing on the plant and equipment. It was about $600,000. The valuation on the plant and equipment came in at $30,000. Now that was due to not only the plant and equipment being older, but also the cost to disassemble and move to an auction house, and then of course there had to be interested parties to buy. So the bottom line was that the return in liquidation from this plant and equipment would have been $30,000. Now the secured creditor of course would not have consented to the sale at valuation prior to liquidation, which is why we entered into a short-term rental agreement. Once that was in place and the business was up and running in the new entity, we appointed a liquidator to the old entity. Importantly, there was staff, there were customers that were coming at all times of day and night, and there was a business that needed to operate without any business interruption, and that's certainly what happened in this case. So as you can imagine, there's also a very big checklist of things that need to be addressed. So once the liquidator had been appointed to the old company, they reviewed the sale contract. They of course ratified the sale because it was commercial based on valuation, and we commenced negotiations with the bank and liquidator at that stage to purchase the plant and equipment at market value. Ultimately they did agree to the sale price of $30,000, and those plant and equipment items were moved over to the new company. Now that also did create quite a significant shortfall for the directors. There was some $570,000 which was going to come to bear on their personal guarantee. The other thing that needed to be addressed was the lease, and throughout this process we assisted in negotiating a very substantial rent reduction for our client. The new trading entity after this had been done was in a very profitable position, and the directors were able to focus on growing the business and running the business without the added complexities of having a second job and also juggling what they did have as previously insurmountable debts. The directors, the advice that we gave the directors personally was to enter into personal bankruptcy, and that would bring finality to the personal guarantee claims that they'd have on the shortfall of the plant and equipment with the bank, finality to personal guarantees for the trade creditors, and also finality to the DPN action that they had from the ATO. Throughout the bankruptcy, the director was able to retain the family home, and that was similar to what Hank spoke about before with the doctrine of exoneration. And the situation with this client was we were able to take them through the Section 73 annulment process about 12 months after entering into bankruptcy. So the outcomes that these clients achieved were that the business was retained, that all personal guarantees were dealt with, and the client was able to retain the family home through bankruptcy and has come out the other side with a clean credit record. The situation, if this was not managed in the way that I've just outlined, would have been significantly different. I would expect there would have been a loss of business, a loss of home, and that client still would have been in personal bankruptcy. The next case study I'm going to go through is not vanilla like the first one. It was quite a complex job to work on, and there was small amounts of strategy everywhere we looked. The background was it was a long-established civil excavation company, and it completed contracts in New South Wales and Queensland. It was historically quite a profitable business, but it did fall into an insurmountable financial predicament, and this was due to a combination of low margin work, wet weather, and high fixed costs. The situation was also severely exacerbated by a relationship breakdown between the husband and wife. Husband and wife were joint directors and shareholders. The husband in this situation knew the business was not performing well, and he was aware that there were statutory debts accruing. However, his wife, who was in control of operating the financial side of the business, wasn't giving him access to the books and records, so he didn't know exactly where everything sat, and decision making was at a deadlock, which was disastrous. The family lawyer who was assisting the husband in this case referred the client to us, and that referral was based on the fact there was director penalty notice and also potential winding up action against the company. We reviewed the situation, and we did determine that although the company was insolvent and could not survive in its current format, if someone could gain control, there was a good underlying business, and a corporate restructure was most certainly a good alternative to investigate. The business in this case was operated through a family trust with a corporate trustee. Our client was able to use his position as appointor of that family trust to change the corporate trustee and appoint a new trustee, which was a company that he controlled. Once control had been obtained, then the decision deadlock was broken. We were able to instigate a pre-pack via voluntary administration strategy. An important element of this job was it had considerable plant and equipment, which was under finance through a large number of equipment financiers. Now, under a pre-pack liquidation scenario similar to the first case study I spoke about, the equipment financiers would have most likely called in their loans and wanted to sell the plant and equipment. Under a pre-pack VA scenario, we had a much better chance of gaining the support of the equipment financiers. So in this situation, a new trading entity was formed, and given our client was completing contracts for multinationals, the business would not have been able to continue to trade and fulfill those contracts whilst trading under either voluntary administration or deed of company arrangement. So our strategy was to license the business across to a new entity, and that new entity was the business that would trade whilst ultimately the old company was under administration. So in order to do this, we needed to establish the value of the business and the goodwill. So there was an accountant that completed the business valuation. The plant and equipment, both encumbered and unencumbered, were valued so that fair market value could be established. The finance, plant and equipment was leased to the new trading entity, and a PPS lease was registered on the PPSR. That was also a very important part of getting the current secured equipment financiers comfortable with the plan. Unencumbered plant and equipment and intellectual property were licensed to the new trading entity on commercial terms based on valuations. This license deed was also registered on the PPSR. The staff were re-employed by the new trading entity, and the staff entitlements were taken over. The new trading entity did need working capital, and the working capital, we were lucky enough to be able to raise that from a specialist debtor finance facility that didn't require the normal 2 years trading history that most do. The new entity commenced trading, and once that was in place, a voluntary administrator was appointed to the old company, or the old trustee company. We assisted the company director at that point to put together a deed of company arrangement. And a deed of company arrangement does need to provide a superior return to creditors than liquidation would otherwise. An important part of this strategy was that the old trustee company had a very significant vote in the deed of company arrangement due to its right to indemnity for trust assets for debts that it had incurred whilst it was a trustee. In addition to that, we communicated very heavily with the equipment financiers and employees to gain their support. So ultimately, the deed of company arrangement proposal was accepted by creditors, and the new trading entity was able to then make one monthly payment or one monthly instalment to the old entity to satisfy what were previously insurmountable debts. So in this situation, the unsecured debts that we dealt with were $1 million, and the deed of company arrangement was settled for $300,000, payable over 3 years through monthly instalments. Now, there were some great outcomes in doing this. Firstly, the business was protected and retained, and at all times the business continued to trade, so the transition was seamless to stakeholders. Like I mentioned earlier, the business itself did not trade under voluntary administration or deed of company arrangement. The employees kept their jobs. The equipment financiers did not enforce their security over the plant and equipment. The creditors certainly received a much more superior return than what they would have through a liquidation scenario. And in this case, director liability was managed at the corporate level, so the director was able to avoid personal insolvency. Now, the situation from the family law side of things, of course, had absolutely no bearing on what we were doing. Our engagement was to save the company and get it into a position where it had a bright future. And the good news is that both parties now can benefit from a business that is trading profitably. The next case study that I'll run through is using a personal insolvency or a Part 10 arrangement to force all creditors to settle. The overview is that our client owned a service station and also a motel in Victoria, and these businesses were operated through a company. They did have substantial funds borrowed with CBA, and due to a downturn they experienced, they did fall behind in the business. The bank did take control. A liquidator was appointed to their company, and at the end of the day, the secured creditors, along with other unsecured creditors, did have a pretty significant shortfall. Now, this client actually came to us fairly late in the process. So this client came to us after the company had been through the formal insolvency process. Now, the directors were younger, and they went to live with their family members to lick their wounds and get back on their feet, and they were lucky enough to be in a position where their family was happy to support them with a loan of $100,000 to offer a settlement to their creditors. Now, the main creditor was the bank that had an $800,000 shortfall, and the bank was actually willing to settle for this $100,000 as full and final settlement and not pursue our client into personal bankruptcy. The problem was that the client had also received a director's penalty notice from the ATO, and the amount on the director's penalty notice was also about $100,000. Now, the client did try to negotiate a payment plan with the ATO. They did try and negotiate an affordable reduced settlement. None of those things came into fruition or were accepted by the ATO. So our strategy in this situation was to make this offer to the creditors, which were, in this situation there were three. So there was the bank that we've spoken about, there was the ATO through the director's penalty notice, and there was also another trade creditor that had a personal guarantee for $2,000. So in this situation, the clients put up a formal offer under Part 10, and when it comes to a Part 10, which is a formal payment arrangement, our client needed 75% in dollar value and 50% in number to support the proposal. Now, because we had been dealing with the bank, we knew that the bank was going to support this arrangement, and we also knew that the personal guarantee creditor was also going to support the arrangement. We were also of the opinion that it was unlikely that the ATO would support the arrangement. In this situation, it did go to the vote, and that's exactly what happened, but because 75% in dollar and 50% in number were supportive, that bound all creditors to the arrangement. So our client was able to use that $100,000 support from the family member to settle with all of the trade creditors as full and final settlement. So that's a good example on how sometimes using the formal insolvency alternatives can be a much more commercial and also timely way to bring conclusion to a bad situation. This whole process only took about 2 months from start to finish, which was a very good result. The fourth and final case study that I'll run through is something that we see all the time, and that's companies involved in litigation, often for amounts that far exceed the asset value of the company. In this example that I'll run through, the client was a Sydney-based product developer, and they enjoyed strong business relationships with Chinese manufacturers, and this client of ours was approached to design, manufacture and supply a product for a national distributor. There were no written contracts in place, and about 18 months later a dispute arose regarding the exclusivity and intellectual property of the product designed. The national distributor brought an action against our client's company for $500,000. Our client felt that this claim was a frivolous claim and intended to defend the action. After many months and some $50,000 in expenses, our client did change his opinion somewhat to the conclusion that this matter was going to be long, protracted and extremely expensive, and also he had absolutely no certainty of what that outcome would be. So our strategy to de-risk this situation for the director was to look at the different insolvency alternatives that might be available, and on review we decided that doing a pre-pack would be the best way to deal with this situation. So the background of the company was that it held minimal plant and equipment assets, and it did hold some stock. Most trade creditors were up to date, so there was very minimal trade creditors and there was no statutory debts. Although the director did owe, the company did owe some money back to the director, because the director had been tipping in those funds to fight the litigation to date. Interestingly, in this company, like a lot of clients that we see, there was a business overdraft, and this business overdraft was secured against the director's family home. So with that background in mind, we came up with a corporate restructure or a pre-pack strategy where we got the goodwill value, we got the minimal plant and equipment and stock value, and we were able to ascertain what a fair market value of that business and its assets would be. Our solicitor documented the sale contract, and those assets were sold across to a new entity. Now, interestingly, as part of this change, in order to sell the business assets, we needed to pay out the secured creditor. Now, in doing so, we needed to refinance the director's home loan in order to raise money to pay out the business overdraft. But the way that that was done was that the new business borrowed money from the bank secured against the home loan, and that money that the new business borrowed was then used to pay out the existing business overdraft or the existing secured creditor from the old entity. Now, by simply paying out this secured creditor, the amount that the new business paid was well above what the fair market value of this business was. So that's how payment for the business was effected. Now, after that had been completed, we then appointed a liquidator to the old company. As part of doing so, the claim was listed as a contingent liability for $1, and the litigation was brought to an end by appointing a liquidator to that company. So the outcome for that director was that they ended up with exactly the same amount of home loan secured against their home. They ended up with exactly the same amount of business debt or overdraft facility in the new entity, but they were able to protect themselves from this litigation or the exposure of continuing to fight or fund the costs of this litigation through an entity that most certainly was not worth what was being claimed, most certainly was not in a position to pay any such amounts if the plaintiff was successful. So that's 4 case studies that we've run through, and hopefully they have been able to show you how, through navigating the insolvency framework, we can certainly improve a director or an individual's outcome. Like I mentioned at the start, for the people that are actually going through these situations, it is more than strategy alone. There's a whole support network that we provide these clients as they're going through these situations, because often there are much bigger concerns, more so than the nitty-gritty strategy that these directors have, and coupled with the amount of pressure that they're under, they really do need intensive guidance. So it is important for them to not only understand or have someone that can help them with the understanding of the insolvency process, but they also need help to understand what their obligations are, and hopefully when they've got a good understanding and plan of these 2 items, then that will take away a lot of the frustration and stress that we often see. I have mentioned a few times that it is never too late to improve someone's position. So any clients that are suffering any sort of insolvency or formal demands or ongoing cash flow issues should most certainly seek information about their alternatives. It is certainly a great idea for anyone in that situation to be well informed. Most of the clients that we all deal with, or I should say you all deal with, are operating businesses that are profitable and they're 10-foot high and bulletproof. Those people in particular are in a very good position to make sure that they put some proactive measures in place. So should something happen in the future, they're in a pretty strong position to deal with it. So some things that we often see or recommend are that company directors should make sure that they've got the correct PPSR registrations in place. And this particularly relates to directors who lend their business money. They should take security for those loans. It will offer them much greater control should something unforeseen happen in the future. The next area where we recommend clients be proactive is with their bank annual reviews. Most commercial facilities have pretty strenuous lending covenants, and from time to time directors are aware that for one reason or another they may have breached those covenants. For example, their tax portal might show that their tax wasn't paid on time. We would urge those directors to speak to us, or at least proactively address those issues with the bank. We often find if the bank is communicated with in a fashion that that they're used to, or in the language that they need, then the bank will often be more than happy to cooperate and address and work with a company director to get things back on track. When it comes to asset protection, I think it's very important to approach asset protection from an insolvency perspective. And the next point is intercompany loans. A lot of clients do have a corporate group, and it's important that they understand the effect that those intercompany loans would have in an insolvency event. And if they understand that, then they're going to be in a much better position to manage those internally. Separation of business and personal lenders, it's a no-brainer, but again, when it comes to retaining family homes, like Hank mentioned with the when he was talking about bankruptcy and the doctrine of exoneration, of course, having a separate home loan lender will put the client in a much better position to be able to achieve that. And the last point I've got on there is that businesses that are performing well and growing often do need some sort of working capital support, and there are most certainly cash flow finance products out there that will lend outside the terms that their main business bank or the Big Four will lend on, and they're certainly worth investigating. So thank you for listening to me now, and I'll hand you over to Dan from the Vincents Computer Forensics Department. And I know that every time I've heard Dan speak, I've learned something new and extremely interesting that I didn't know. So Dan, I'll hand you over. Cheers.
Thanks very much, Ben. Hopefully everyone's able to hear me now. So it's a pleasure to present to you today. My name's Dan Haynes. I'm Director of Vincents Forensic Technology. What I thought we would talk about today was the basics of computer forensics. So we'll talk about an introduction, what is ESI versus digital evidence. So in the current climate, we do have a vast array of information that's stored electronically versus the evidence that we actually need, which might be a very small amount of the massive amounts of data available. So we'll talk about that. Phone forensics, I'm finding, is a big topic at the moment. So I'm certainly happy to speak about that. And what are some of the tools, techniques that we use in interrogating data? And a topic that comes up always in questions when I do presentations is look, what's the cloud and why should I care about it? So we'll cover that as well as we go. My role essentially is in interpreting digital information, the content of which can't generally be interpreted without using computers. So we're now using computers to store data, and we can't read that data ourselves without using another computer. So it's the first time in our history where we're basically not able to pick up a document or view something directly and interpret it ourselves. So that's essentially why this science has grown out of from what used to be a very boutique and unique law enforcement tool in terms of analysing computers. We're now finding it far more prevalent in society. So what I'm about is everything you see on the screen, and that's the identification, the preservation, analysis and presentation of electronic evidence, the source of which can be anything from computer servers, SD cards, CD-ROMs, smartphones, almost anything you can think of. Photocopiers, we can identify information. We must preserve it. My domain tends to be in the field of litigation, but also in terms of insolvency matters as well. And that is, we can't go to court, or we can't wheel in a computer every time we need to look at an email or we need to look at a document. We need to make sure that this information is preserved for as long as we can and that it's presentable in court. And analysis, of course, always has to be done as efficiently as possible. There's no point in charging people telephone number type fees to find documents. It's all done very efficiently, and we have very powerful software that let us find things very quickly. Everything I do is with a view to presenting it in court, either in the witness box or perhaps in a report, which it can be easily understood by anyone, and that's a huge part of what I do is communication. It's not limited to mere computers anymore. It's not a matter of attending a site, grabbing someone's PC and finding illegal information or preserving emails. Computer networks are certainly a big part of what we do, but it's extending now to all aspects of data. So it can be the internet, it can be the cloud, it can be on phones, consumer electronics. I mentioned photocopies already, and online storage services such as Dropbox, BoxNet, SkyDrive, Google Drive. All of these things are now well within the purview of storage information, and it's not a matter of simply being on someone's computer anymore. I know the prevalence of Dropbox is worrying a lot of our clients in terms of securing their data and securing their intellectual property, most of which these days seems to exist electronically. So it might be a cache of documents that you use to communicate with clients, or your business plan, or your price codes, or your stock codes. That tends to exist electronically, and often it's fairly unprotected. Years ago, we would see most theft of intellectual property happening in terms of emails. Up until recently, a lot of data was being lost through USBs, walking out the front door, basically in people's pockets. A lot of what we see now in terms of data loss is through Dropbox, where people can drag files or folders into a simple online service that gets synced somewhere else, either to their new employer or to their home computer, and they can then remove the online service and leaving little trace. So it's a big thing of what we're seeing now. In terms of understanding what I do, that's really quite simple, and I'll show you a video presentation soon that hopefully should explain a lot of it. If you think of the diagram on screen now as a basic hard drive, and that exists as a series of grids. So these are sectors of a hard drive. This is the physical hard drive on your computer. Hopefully you can see what I'm highlighting there. Now, computers really have no intuition, of course. They have no intelligence. So they keep track and keep a record of everything that they do. And what you see up here is file 1, file 2, and file 3. That's actually the index table for the computer. This is where a lot of the data about the data, or metadata, is stored. So computer knows that file 1 is in the second row. It's 3 sectors long. It's called file 1. It was created on a certain date. It's still active, as it's still present on the hard drive. And any other information about that file is stored in the index. Now, the actual file itself is still there, so you can see file 1, file 2, and file 3, and that's a very simple representation of a hard drive. Now, if we move through the presentation, just having trouble with my highlighter here. We can basically see that what's happened for a deleted file is this, that the computer doesn't go to the file, scrub it out, move all the files around so that they're all one after another, and basically check that everything's okay, because we would lose speed, and the most thing we want out of a computer is really its speed. So all it does in the file index that I'm highlighting here is puts a little tick saying, look, this file has been deleted down here, and that space is available if I need it. So you can see at this point, if someone like me comes in and takes a snapshot of the hard drive at this point, I can simply and very easily recover file 2 and undelete it, essentially, what we would call a copy unerase type exercise. So that's the basics of that. You can see the problem with that being later on, subsequently now, we can see that file 4 has arrived and file 2 has been what we call overwritten. We know it was still there because we can see the index. We can know it's still there. We can see the index, the file still existed. It was in this location. It used to be there. It's not anymore. It's been overwritten by file 4. And in this example, there's very little case of recovery. So when people come to us and ask us if they can retrieve a file that they deleted yesterday, then normally we would have this type of situation where file 2 still exists. If a file was deleted 6 months ago, a year ago, or longer, and they use their computer quite a lot, and they download a lot of large files, then often we'll get the situation that you see here, file 4, and it's no longer recoverable. And that's the basics of computer forensics. So I've mentioned already the process of a forensic image. That is on this side. So we basically take a snapshot of everything that's on the hard drive. So we'll get things that are active and deleted. We can recover anything that's deleted and recoverable, but we'll also get privileged and confidential documents. We'll get everything that's relevant to our case and not relevant. It is a little bit slower, but it provides flexibility for in-depth analysis, and it gives us a read-only copy that we can preserve and use in court. It's very verifiable. We can provide that copy to another expert, and they will get the same results as we do. It's far better than a file copy, just a right-click copy-paste, where you might be changing dates or file metadata around the files that are important. You can't go to court and say, look, we just did a quick file copy and answer the question from the judge that, look, have you tampered with this evidence, because it's not verifiable. Here's a good example of a very simple imaging job that I did. It relates to what Ben was talking about earlier. This is my laptop here that I'm highlighting here. This is what we call a write blocking device, which ensures that we only have a one-way flow of data from the hard drive, which is here, you can see in the computer, all the way through the write blocker and back this way. So nothing that I can do can change the evidence on the hard drive, and that's very important in terms of litigation. The evidence then can be written out to the device, a hard drive behind the computer here. And this was a good case for us because this was a gymnasium a young couple had purchased. They found very quickly that the financial results weren't what they were promised to be. They had far fewer members than what was promised to them. And when they purchased the gym, obviously they purchased the equipment as well, including the computer. So this is actually the office computer, the hard drive. We took an image of it, we analysed for deleted files, and we're able to locate spreadsheets and various documents that showed that the previous owner had in fact falsified the number of members. He'd falsified the condition of the equipment and the requirements under the lease to replace that equipment and various things. And so we were able to go to a mediation prior to the business being put straight into insolvency. We were able to go to a mediation with the other side, present the evidence that we had, and that we were entitled to recover some of the purchase price, and that's eventually what occurred. So that person had to refund a huge portion of the purchase price, which allowed the owners of this business, the gymnasium, to continue to trade and replace the equipment that needed replacing, and it was a really great result for them in that regard. So that's a good example of what we can do. I've spoken about metadata already. This is a simple example of metadata. So metadata is data about the data, essentially. If you think of a letter as being the important information inside, things outside you can tell about the letter. It came from a location, it's been through various sorting services, so it's the data about the data. If you're thinking of a Word document, the important data might be the text, and the data about that data, or the metadata, might be when was it last saved, when was it created, and that can be very important in terms of checking on claims and various things like that. There's a way that we can verify that the evidence is forensically sound, as in what we've taken is an exact copy or a fingerprint of an exact copy of a file, and that is we fingerprint the evidence. So we create what's called a hash, which is a mathematical algorithm of the contents of the file, and it means we can say with absolute certainty that two files are exactly alike. They're completely the same. Even the metadata is the same, so the data about the data is the same. And this is a real cornerstone of what we do. On your screen now you've got what a hash essentially means, or a digital signature. So you can see that the text of these two boxes is the same, apart from one has a full stop and one has a comma. You would think intuitively that the hashes or the fingerprints of those files would be the same, but in fact they're completely different. You can see down the bottom here, that's the mathematical algorithm or the hash that's applied to each, and they're completely different. So we know when evidence has been tampered with, we know when files are also identical, and the inference is that theft of a file from an employer perhaps can only occur where the files are identical. So there's no other way that they could have generated an exact file. So it's a great tool for us. All right. So the benefits of computer forensics: we can recover deleted files, we can preserve metadata to prove in court that what we've done has all been forensically sound. The data is read-only, it's very portable and verifiable, so there can be no, in court, there can be no problem in terms of the provenance of the evidence itself. It's all very verifiable. It's all very repeatable. If I do a search on a forensic image, someone else who searches for the same objects will find the same thing, which might not be the case if you just take a copy of a portion of a server and then that server is put back into use. The data might not exist anymore. So it's certainly the cornerstone of what we do. So information today involves perfect copies. There's no degradation of that image at all, ever. And that's the danger as well with theft of digital information. Once the horse is bolted, any number of copies can be made, and so you must prevention is the best way of protection of your intellectual property. Which brings us to the other topic I was going to talk about, and that is the cloud. So, sorry, if I can just talk about in terms of virtualization. So a big benefit to our pre-insolvency and our insolvency practitioners is the fact that evidence can be virtualized, so we can create in our lab a server, a working network that may have existed previously on 5 computers. We can create that whole network on our single server. So we have no infrastructure actually running. It's in fact simply existing electronically on our network, and we can then reach in, turn the computer on, we can run applications, print invoices, send emails and review documents as if we were still sitting in the former site. So perhaps you might have a warehouse that you can no longer be paying rent on. You've lost access to the site, but if we've imaged all the servers, we can still operate the design software or emails or invoice software as we had before. So it's a very useful benefit for our clients. Quickly talking about phones, basically the principles are the same in terms of mobile phones. So we use dedicated phone forensic equipment for the acquisition. The extraction methodology is also the same, and we ensure that the analysis is all logged, documented, and the evidence is preserved. So we have a phone, we apply our hardware, which is read-only hardware, and we acquire an image of the phone out to a different device, and we're then able to do analysis. So we can grab things like the location of the phone, the internet history, contacts, notes, calendar, appointments, SMSs, often deleted SMSs. So we can all get that from a phone. Very useful. Contact information is available, so latitude and longitude that we can actually graph onto something like Google Earth and grab a location of a subject. So it's all very useful in terms of phone. So you can think of a phone as you would a computer. Moving on to cloud storage, which is relevant to the discussion of protection of intellectual property. I've already mentioned factors such as Dropbox, Box.net, SkyDrive, and aspects such as that. So these are all cloud-based storage solutions. There's a lot of confusion on terms. Basically, the cloud refers to an environment that's not specifically or centrally located. So you can think of your data as being very mobile. It might exist on a server in Hong Kong in one day, it might be in Seattle another day in terms of its actual location, but it's always accessible to you. So wherever you are, you can view your data on the cloud, and that's the advantage of it. Your computers are not the ones storing the data, so there's a reduction in infrastructure. Your computers are not the ones doing the work, so they're not actually processing the data. All you need now is a web browser, which takes up very little processing memory within a computer, and you can then access all of your invoices, all of your emails, and it's all very adaptable. It's secure, it's backed up, and it's always available. So that's, when we're talking about the cloud, that's essentially what we're talking about. You have fewer support staff, easy to maintain. There are some cost savings in terms of infrastructure. So these are all the benefits that we can identify up here, the purported benefits, I should say. You should also be aware of the downside, and that is you don't know where your data is. And there are some legislative requirements around where data should be, especially if you're a medical centre or a barrister or anyone that has Privacy Act type requirements. Even though your data is available, you need to know where it is, and it needs to be under your control. Security, just check on how good your security is and make sure you're aware of who has authority to access your data. It's very available from anywhere, which is an advantage. That can also be considered a disadvantage as well. Make sure you have an exit strategy if either you or the person providing you with the cloud service gets acquired or perhaps changes conditions. Make sure you either have rights to your data or you have a local backup of your data. Make sure it's obviously it's not open to corruption and it's recoverable. What are the disadvantages? So we've discussed those already. Where is your data? There are legislative considerations. Who has access and who can access the data? So there's a difference to who has access and who can access. And make sure that it's secure and that you go with a well-known provider. Why should you care? Well, this is the way the world is going. There's no doubt about that. People will resist given that it's a change and people are very change resistant, but the investment is going this way. The money is flowing to cloud-based solutions. So by 2016, it's projected to be a $67 billion industry, which is obviously massive. So if you want to protect your brand and your intellectual property, you need to start being prepared for this shift in the way we store data. There may not necessarily be the server room anymore where you know where all your data is. It's next door in the server room. It might be up in the cloud. Certainly your clients may be up there as well, and you need to be aware of what's happening and how to advise them. So save your data on the cloud. You can back up or sync your files anywhere and share it online. And that shareability is the problem for a lot of people in terms of security. There's a lot around. There's Box.net, which is one of the first ones. Dropbox, which is a great, very well-marketed company. They've used the approach to make aspects of their service free to a lot of people, which becomes sort of a gateway type drug. People use this thing for free. They recommend it to their friends. It spreads, and they will grab a large share of the enterprise market very soon. Google Drive are doing the same thing. iCloud, I'm sure we all have data on iCloud that we don't know about, especially if you have a mobile phone, and there's various other ones as well. Each vendor has their own client for syncing the data, but generally it involves downloading a small application to your local computer, be it at home or at work, and that little application basically transfers your data across available bandwidth up to the cloud. You can then access that data from anywhere. So very simple to use, and it's very, very easy for you to lose control of your valuable data. So be aware of it. This is just a quick grab of various solutions that are out there. The ones that most people will be familiar with are Boxnet, Dropbox, SkyDrive, Amazon, Google. They're all, Evernote's very big as well. So they're all out there. People are using them. If you're not familiar with them, you can be sure that your employees are, and they're using them already. We've got a question. Dan, do we need to get authority from our clients to save their information on Google Drive? That's from Cole. Yes. Yes. Generally, it's implied if you let them know that that's what's happening, or perhaps they're using that service to reach you. But yes, you do need to get their permission, or at least you need to have in your terms of use or in your own documents themselves information for the client that that's what's happening. So I think being transparent about it is the best way to go. I'll just move on. Evidence in the cloud. Look, cloud services are inherently viral. New users are drawn in by internal and external colleagues, and this is what I was alluding to earlier, in that a lot of these services at a personal level are free. So you're given 2 gigabytes for free. I think Google Drive will give you 10 gigabytes for free, and it's encouraging you to use their service. So again, it's that gateway approach, and they're getting, in terms of enterprise solutions, those are becoming cheaper all the time. So people that use Dropbox personally are more likely to recommend to their employer, look, this client has some large documents that we can't email. How about we just use Dropbox? And again, that's that viral aspect, that then you've got different people using those cloud providers, and everyone is jostling for position at the moment in the market. Office 2013, Office 365, which is coming, as well as driving people to the cloud. You'll be able to store your documents for free. If you buy a copy of Microsoft Office, they'll give you an allocation on the cloud to use their service for free. So it is happening. And I've probably spoken enough now. If I can leave you just the basic points, is that, look, we use computer forensics to collect electronic evidence, recover data, even if it's deleted or corrupted. We can defeat some passwords. We can trace and verify the authenticity of electronic documents, emails, and transactions. We can use it to virtualize infrastructure and reconstruct electronic events. And a lot of what I do is preparing reports and providing expert testimony. I'm happy to answer any questions. You can certainly reach me on Twitter, Vincents Forensic Technology. We have a Facebook page, or the good old internet at vft.com.au. That's all the content that we have today. I'd like to thank everyone for attending. Hopefully we've been able to answer a lot of questions and provide a lot of information, certainly from Jonge Read and myself. Thank you all very much for attending, and I look forward to being in touch with you all at some stage in the future. Thank you very much.